Welcome once again to Lehto's Law. Here's Steve Lehto.
Kelvin sent me a note out of Kansas and said, check out this story from KAKE. Warrantless searches of rural Cowley County home struck down by federal court. Warrantless searches. Federal court has ruled in favor of a Cowley County bird dog trainer and his wife, ruling that warrantless surprise searches of their property are unconstitutional. Now, that's the kind of thing where the court is stating the obvious, but you see sometimes when the authorities are doing something wrong, it appears obvious to everybody they're doing something wrong, but until a federal court tells them to stop, sometimes that's what it takes. The ruling in favor of the couple was issued by U.S. District Judge Warrantless following a federal civil rights trial that concluded back in May, according to a press release from the Kansas Justice Institute. The court found that the state's practice of conducting unannounced inspections of private homesteads and property without a warrant, notice, or consent violates the Fourth Amendment. So without a warrant, of course, but notice, like they don't even tell you they're coming, and, of course, no consent. Because if you consented to it, they'd be allowed to do it. But the litigation director for the Kansas Justice Institute, Sam McRoberts, says, this is a landmark victory for the couple and for every American who values the sanctity of their home. The Constitution's promise that our homes are our castles was upheld, and rightly so. And I suspect that the vast majority of my audience, and by that I mean about 100%, agrees with this ruling, that the government should not be allowed to come in and just snap inspection of your place. Case arose when the man, who is a nationally recognized dog trainer, and his wife challenged the law in Kansas, which requires licensed dog trainers to submit to unannounced inspections of their private homestead under penalty of fines or loss of licensure. So if you're licensed as a dog trainer, you are subject to SNAP inspections, or at least you were. The lawsuit was filed by the Kansas Justice Institute on behalf of the couple back in 2022. In 2024, the U.S. Court of Appeals to the 10th Circuit reinstated the case after it had been dismissed. So the trial court, when they first saw this, dismissed it. And the appellate court said, you know something, we're going to reinstate it and let them have a trial. So the state was arguing that its inspections were because this is a pervasively regulated industry. And that would be an exception to the Fourth Amendment's prohibition of warrantless searches. And so there are some cases where you might say, you know, I can kind of understand why they should be allowed to do an unannounced inspection of a certain kind of operation based on what they're doing. But it would have to be so narrowly tailored, the rule would be, to prevent it from just being used all over the place. And so the state here was saying, well, this is a pervasively regulated industry, and apparently pervasively regulated industry is language that the courts have said, if that's what this is, then you can do this. But here the court's saying, you can't just say it's pervasively regulated because you regulate it pervasively. Otherwise, you could just say anything is that, and you can then do that. So the exception is recognized by the U.S. Supreme Court for certain industries, such as mining. So you're operating a coal mine, which, by the way, is a relatively dangerous profession. They can show up, mine inspectors can show up and inspect your mine. Now, I think most people can get on board with that and go, wait, so you're running a coal mine or a copper mine or some other kind of mine where people are underground using explosives. They got rock overhead. People do get hurt. And mine inspectors show up to do some inspections. Most people would say, I have no problem with that. Because number one, it's not somebody's home. And number two, it is an inherently dangerous business. That makes sense to me. However, back in 2015, a court had to rule on whether or not hotels were pervasively regulated, because Los Angeles had tried to make the argument that they should be allowed to just jump in and do these inspections on hotels without any kind of announcement or warrant or anything like that. And the court said, no, that's Just because you call it pervasively regulated doesn't make it so. And it's got to be the kind of industry where that would make sense. So the judge rejected the state's argument that warrantless inspections of training kennels were justified, warning that that logic would essentially turn any industry into a closely regulated one and would swallow the rule. You know, the old saying about the exception swallows the rule. So the government must obtain a warrant before conducting a search of dog kennels in Kansas. And so it's interesting because I'm sure that this is not going to help a whole lot of other people explicitly, meaning they didn't list, here's everything that is pervasively regulated correctly, here's everything that's not. What they're basically saying is, you got to take a better look at it than that. So this case is not just about this couple, says their attorney, is about every Kansan's right to be secure in their own home. And again, they're running a business out of their home. And following the logic of the government, they get to come in and inspect the business, which includes their home. And that would be invasive. Government can't sidestep the Constitution just because it finds it inconvenient. So we are pleased that the federal court saw things our way, he says. That's the attorney. The well-being of the animals in our care is priority one around here. Our clients know and appreciate that about us. This will come as a relief to other trainers and boarding kennels around the state. So specifically, they address here training and boarding kennels. And these people, that's what they do. And so it's right on point that if you are somebody who operates a business like that, that you now know going forward, at least in Kansas and so on, that you have the right to not be subjected to these warrantless searches just because someone decided to check it out. Now, don't get me wrong. If somebody sees something happening bad at one of these kennels, they can report it to the authorities. The authorities can investigate and then potentially get a warrant. Okay? But the interesting thing is, nowadays, it's actually not that hard to get a warrant. If somebody saw something bad happening at a dog kennel, bad conditions, mistreatment of animals, whatever it might be, they could go to the authorities and go, here's what I saw. And they could be asked to sign an affidavit, which might be submitted, and they could get a warrant, and then go in and check it out, if that's probable cause. But the whole point behind getting a warrant to search or a warrant to arrest or anything is that there is law enforcement out there, whether it's police or game wardens or sheriffs or whatever it is, law enforcement. And they want to do some investigation. And they have a hunch, they have an idea, or they're bored, whatever it might be. They just decide they want to investigate something. Well, the Constitution says they can only do that with a warrant. So the point is you go get a warrant, and the fact that you go get a warrant means, by necessity, you're getting it from somebody else. And it's supposed to be a buffer. It's supposed to be the voice of reason. It's supposed to be that you can't do it just because you want to do it. You got to go and explain it to an impartial third party and say, here's why I want to do this. And they're supposed to look at it and go, oh, that makes sense, or no, that doesn't make sense. And so one of the interesting things about this is I wonder if, without being able to do these snap surprise inspections with no warrant, will they be able to get warrants? Because is anything happening here? Or are they just doing these because they could? And that's another problem. And again, I'm not talking about all law enforcement, but we all know there are some people who get into law enforcement, and when the power is given to them, it causes them to go just a little bit astray. Just a little bit. Just a few people. So the warrants are there for a reason. You're required to get them for a reason. And this is a good ruling. So as of right now, in Kansas, they need to get a warrant to come in and search a dog kennel business. And they can't say, well, we regulate it heavily, therefore we're allowed to do that. Well, no, it's the other way around. It's supposed to be a kind of business that needs heavy regulation that would then require this. And like I said, the example they give is mining. And that would be the kind of inherently dangerous business that you'd want to be subject to more inspection than anything else. So there you go. Calvin, thanks for sending that. It happened in Kansas. K-A-K-E ran it. Warrantless searches of rural Cowley County home struck down by federal court. Questions or comments? Put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. At this time, there will be no questions. Are there any questions?